Did Alberta, Canada resident Patrick King prove that COVID-19 is a hoax, causing an end to COVID restrictions in Alberta? No, that's not true. King's attempt to subpoena the province's chief medical officer for his COVID-19 ticket was denied because the health agency successfully argued his request was irrelevant to the case. The timing of Alberta's changes to mask requirements and other restrictions is not related to King's case, which he lost. The claim appeared in a video posted to the Stu Peters Show BitChute account on August 3, 2021, titled, YUGE. Canadian court victory proves COVID-19 is a hoax and amp. All restrictions have now been dropped, which open, quote. Patriot Patrick King represented himself in court after being fined $1,200 for protesting against the COVID hoax. He slew the beast and emerged victorious. He issued a subpoena to the provincial health minister for proof that the so-called COVID. End quote. Users on social media only saw this title, description and thumbnail, quote. YUGE. Canadian court victory proves COVID-19 is a hoax and amp. All restrictions have now been dropped. Patriot Patrick King represented himself in court after being fined $1,200 for protesting against the COVID hoax, slew the beast and emerged victorious. He issued a subpoena to the provincial health minister for proof that the so-called COVID. End quote. King made the false claims on the Stu Peters Show, an online forum known for peddling COVID-19 conspiracy theories, several of which Lead Stories has debunked. Readers can review past debunks here. Peters introduced King as a man who was fined $1,200 for violating COVID-19 rules in December 2020. King claimed that in his court case he was able to prove the Canadian government admitted COVID-19 does not exist. King said he did this by issuing a subpoena to Dina Hinshaw, the chief medical officer of health in Alberta, and being refused. At the 2:21 mark in the video, King says, quote, I produced some information that I needed to request in order to put up a good plausible defense. My material I requested was the isolation of the SARS-CoV-2 virus. And I wanted it isolated and not in a lab setting, nor in a PCR test. We know a PCR test, they're overspun. We're not stupid people. We know the research. In doing that they kind of shut me out of court. End quote. King and Peters said in the video that the virus was never isolated. Lead Stories has reported there is proof of the isolation of the virus. Clinicians and lab researchers working to stop the spread and to treat the most stricken of the millions of Americans infected so far with COVID-19 rely on the following proof. The SARS-CoV-2 virus has been isolated and its means and ease of transmission have been proven by multiple scientists working independently of one another. For examples, see the Centers for Disease Control and Prevention, CDC, footnote list of 25 published research papers about airborne spread of the virus. King claimed he was allowed to subpoena Hinshaw. At the 5:21 mark, King claims as the case progressed, Hinshaw's attorney said, Mr. King is requesting evidence that we cannot give. He shared a screenshot from what he claims are court documents that read, the CMOH has no material evidence. Source. BitChute.com. Screenshot taken on Saturday, August 7 at 3 hours 20 minutes and 17 seconds 2021 UTC. King's recapitulation of the government's position misses the nuance, which is that the agency successfully argued King has no evidence to support his claim the virus doesn't exist. The document provided on the Stu Peters Show spells it out, quote, Mr. King has no evidence showing that the evidence sought from the CMOH is likely to be material to the provincial court proceeding contrary to SS. 698 and 699 of the Criminal Code. As such, the Justice of the Peace did not have jurisdiction to issue a subpoena, and it should be quashed on that basis. End quote. Hinshaw's office emailed Lead Stories a statement refuting King's claims on August 6, 2021, quote, This concerns a violation of a CMOH order, which is an offense under the Public Health Act. The court decision regarding the subpoena was a preliminary technical matter. It was argued that Dr. Hinshaw did not have any material evidence to provide that would be relevant to the matters to be decided at trial. The court decided to quash the subpoena. It is false to claim there is any relationship between the decision on the subpoena and the lifting of public health measures. Mr. King was ultimately found guilty of the offence at trial and sentenced to pay a fine. End quote. Timothy Cofield, University of Alberta, Canada research chair in health law and policy, told the Edmonton City News that the claims King made were a conspiracy theory that is both legal and scientific misinformation.